being here. Mr. Adams, welcome. Introduce yourself and go ahead.
Thank you, Chairman. My name is Will Adams. I'm a former president of the Texas Trial Lawyers Association, and I'm here in opposition to the bill. It's an honor to appear in front of this committee, and frankly, an honor to appear next to Mr. Austin. Mr. Austin and I got to know each other a long time ago when he was a Sigma Chi at Sam Houston State University, and I would visit my friends there. And we recently reconnected, and oddly reconnected for a second time as we ran into each other over on the sidewall. So it's good to see him. He runs a good company. My president, Jack Walker, asked me to speak on a very specific portion of this bill, and that is the medical bills portion. It's been discussed a lot today already. I've been listening to the questions and the comments, and I want to be as direct to those as I possibly can. There's been a lot of talk about lying and cheating and fraud and that sort of thing. My personal experience is different, not just in my practice, but with my colleagues and my friends who are in the association with me. So it's not my experience. It sounds to me like what we're trying to do is legislate towards that fraud, which I get wanting to do. The problem is when you try to legislate the bad apples, you're sweeping in the rest of the bunch with that. And I want to talk about that today specifically, and how this bill would impact cases and injured Texans who do not fall under that accusation in any form or fashion. So the way the bill works quickly in 4104A1 and 2, if the injured victim has the means to pay for their own bills, they get those recovered. If someone pays them on their behalf, third party or not, they get those recovered. What this bill impacts the most are those who cannot pay their own bills, do not have their own health insurance, or cannot use it for one reason or another. And so what this does, and I want to be clear, this does cap medical bills that can be recovered. 4104A, it says the economic damages that may be awarded for healthcare services are limited. And then it sets forth those 1, 2, and 3. The third one is the major concern, obviously. It's the 150% multiplier on what I understand at this point is going to be workers' comp. So 2, what I believe are unintended consequences of that provision and how it will impact cases that I think we all would agree don't fall into that accusation. So picture this. A young woman is in a terrible crash. She fractures her hip terribly. She doesn't have health insurance. A surgeon agrees to operate on her and afterwards sends a bill for what is the range of either what private insurance would pay or the cash pay rate, which from what we've been able to determine is between $10,000 and $20,000. That woman is forced to file a lawsuit on that between $10,000 to $20,000 bill. Why? Because with this law being in effect, the auto insurance company for the responsible party is only going to pay what's under 411043, which is 150% of that's what I understand is the comp rate. From what we've been able to determine, that's $4,137 approximately. The young lady who was injured through no fault of her own has a $10,000 to $20,000 bill. She still owes it. This law doesn't cap the bill. It caps the recovery at trial. The bill remains. So a lawsuit's filed because the auto insurance company does not want to pay the $10,000 to $20,000 bill because why would they? This bill says that all this young lady's going to get at trial is the $4,000. I disagree with the witness who said that this will decrease the backlog. This will increase the backlog of cases for this very reason. May I wrap?
Go ahead, thanks.
The one thing that we should all want to do is avoid shifting the harm back to the injured victim who was injured through no fault of their own. The only people that that is good for is the wrongdoer and their insurance company. Thank you, Mr. Chairman.